Exercise 14. Start. This reference has been made by the temporary sessions judge, Faizabad, recommending that an order passed by the magistrate under section 145 bracket 6 close, Code of Criminal Procedure dated 11/4/1970 may be set aside and possession of the disputed plots be delivered to the applicant before him, A.K. Das, stop para. M.T. Das, opposite party, filed an application under section 145, Code of Criminal Procedure before the magistrate that he is in possession of the disputed land and that A.K. Das, applicant, had been interfering with his possession. Stop. The magistrate called for a report from the police, which submitted its report to the magistrate, confirming that there was an apprehension of breach of peace between A.K. Das and Raja Ram Das. Stop. Thereupon, the magistrate passed a preliminary order under section 145 bracket 1 of the code on 11/4/1970, directing at the same time attachment of the disputed land. Stop. The parties filed written statements and affidavits in support of their respective claims as regards possession, and on 25/4/1970 the magistrate passed a final order under section 145 bracket 6 of the code, holding M.T. Das of Sri Raman G in possession of the disputed plots and entitled to retain such possession until ousted in due course of law, and forbade the applicant A.K. Das from interfering with the possession of the opposite party. Stop. The plots were accordingly ordered to be released in favor of M.T. Das. Stop. Against this order, A.K. Das filed a revision, which was heard by the temporary civil and sessions judge, who has recommended the setting aside of the order of the magistrate on the ground that A.K. Das was, in his view, all along in possession and not M.T. Das, and that the magistrate was wrong in recording the conclusion that M.T. Das was in possession. Stop para. After hearing the learned counsel for the parties and on a perusal of the judgment of the civil and sessions judge and the explanation of the magistrate, I am of the opinion that this reference cannot be accepted. Stop. The reference was based on the case of A. Ullas versus State and an unreported decision of this court in civil revision number 349 of 1966 bracket Allahabad, stop, Srimati Devkali versus Sahodar, decided on 8th November, 1937, stop. The civil and sessions judge improperly interfered with the finding of fact recorded by the magistrate. Stop. A sessions judge cannot review a finding of fact recorded by a lower court and cannot enter into a reappraisal of the evidence himself. Stop. A sessions judge cannot interfere in revision when, according to him, there is an error on a question of fact. Stop. He can do so only in cases where there is an error of procedure or law causing substantial miscarriage of justice. Stop. Of course, a finding of fact can be interfered with if material evidence has been ignored by the lower court, but in this case it cannot be said that any material evidence bearing on the question of possession which was before the magistrate was ignored or not considered by the magistrate. Stop.